Now, my story is kind of convoluted, but I'm going to try and keep it short because I explained this before. I spent 36 years in the Marine Corps Reserve, was in 14 and a half years before I got married. I was a gunnery sergeant in E7, and I was married 16 years. And then 11 years ago, I went through my divorce and went to court. My ex-wife said, "Oh yeah, I want part of your retirement too." And I was like, "What? What?" And my attorney said, "Yeah." And I said, "No." And she said, "Yeah, the judge is going to give it to her anyway." I said, "You're kidding me. I didn't know that was a thing. Nobody ever told me. I never got any briefing from anybody saying that it could be divided, any of that crap." So we went through this long.
It can't.
What's that?
It can't. They did it anyway. I realize that, but
yeah.
Continue.
But never in my time in the Marine Corps did anybody tell me about this law, the Former Spouses Protection Act. It was passed in 1982, 2 years before I joined. And so they required that not only did they assign child support, my ex was living with her parents 6 miles away from my house with the kids. Here it is 11 years later. She still doesn't work. She's 53. I'm 60. She still doesn't have a job. Complete loser. And they ordered me to pay disability. Now, I was unemployed at the time. I had spent several years on active duty, but I was unemployed and looking for work. And the court forced me to go to work. So I had to go to work. The only job I could find was working in a warehouse. It exacerbated my injuries. Took her back to court, went back to court, and they increased my child support by 79%. Child support and alimony.
Wow.
79%.
Yeah, I was already paying $2,000 a month.
Did they give a justification for this?
Nope.
Of course not.
My attorney, I didn't realize what a scumbag he was at the time, but he says, "Well, if you go in front of the judge, he's going to raise it." Because I told him, I said, "No, man," I said, "I'm already struggling." So they were taking my VA disability on top of my income, and then I was doing extra work for Uber, DoorDash, and stuff like that, and they were taking that too. Every little bit that I tried to make up, they went to take. And so then also they appointed a third-party attorney to divide my retirement. And this guy was demanding things of me that I didn't have, information I didn't have, based on my service, the points in the reserve, you earn points. And he wouldn't tell me how he wanted it or in what format. So he just recommended to the judge that, well, she's just going to get 50% of his entire 36 years. Now, I was a gunnery sergeant E7 when we got married, but I was a W4 when we divorced, or before we divorced. I was actually a W3. And then retired as a W4 5 years later. And the judge just said, "Okay, we're going to give her 36% of his, or 50% of his entire 36 years. No due process, nothing. I wasn't even in the courtroom, didn't have any say in it." And,
wow.
And then they
50% of 36 years, as in they backdated it for your entire military career, and you were to give her 50% of that?
Yep.
That is crazy.
Before
what in the ass?
Yeah, it is. It not only is it a violation of state law, it's a violation of federal law, all kinds of things. But in the order, there's an indemnification clause that says if I elect CRSC, combat related special compensation, then I have to indemnify her for any portion that is reduced due to that, which is a violation of Title 10, Section 1408, because the only thing that's divisible is disposable retired pay. So, long story short, we now have a case in front of the Supreme Court. I filed it. Bob did a lot of the heavy lifting, did a lot of research on it, and it's in front of the Supreme Court right now, distributed for conference on October 10th.
All right. So we got everyone's story on board. Let's.
I tried to make it the Reader's Digest condensed version, but it's much more convoluted than that.
It is very convoluted. This is the actual case. What have we got, Tom? What are we looking at?
So this is it's a petition for writ of certiorari. We're asking the
Okay.
court to answer these three questions, whether the states, and you scroll down, you'll see the questions.
Question 1 presented.
Beautiful. Look at that.
Whether
Beautiful.
the states are bound by the Former Spousal Protection Act, whether they're bound by the Veterans Judicial Review Act, and then whether or not they're liable for their violations of violating Titles 10 and 38.
That's the big one right there.
Big one
That's
right there.
the big one. And I'll tell you why. If this gets decided in your favor on that point alone,
They're done.
judges will stop pulling this nonsense because now they're liable. Personally, it becomes personal.
That's the idea.
Yeah. I like that a lot.
Here's my idea. Okay. If that actually goes in your favor, which in my opinion, from what I've seen, you actually have a decent chance at it.
Oh, yeah.
We can actually see if we can get a nationwide movement to go after all of the judges that have ever put an order in the past, 7 years against a disabled veteran, and go after these judges personally.
Absolutely.
That's our goal.
Yep.
Yes.
That's
But you know what? Remember this. The judges are doing what they're conditioned to do. They're following
Yes.
the leader. They do not want to admit 35 years of predatory corruption and profiteering because that would expose, they don't want to admit the lack of jurisdiction because that would expose them personally as well as all of their colleagues, because the lawyers who are profiteering on these families are real scumbags, and some of them need to be disbarred and thrown out of the country. But the real dirty birds in this are the state employees who are using this system, Title 4D, to pad their paychecks by committing the predatory embezzlement of these federal funds. From the beginning of Title 4D, veteran benefits have been exempt, except for a couple of years, retirees could be garnished. Regular veterans could not. And when we got up to 1987, the Rose versus Rose case, everybody says that the decision in Rose made it clear that states have control of those benefits just like regular income. It's part of Title 4D. And even if they can't garnish it directly because 659 didn't allow them to just garnish through the VA, the state could still take that as income and split it up and divide it. The point is, when Congress came along and read that, the Rose decision actually said that there was an imaginary exception to the anti-garnishment statute, the one that said they can't take veteran benefits by assignment, they can't garnish, they can't put them in jail, they can't take that money anyway under any legal or equitable process, whatever.
Now, let's throw Rose up here real quick so people can see what we're talking about. It's 41 U.S. 619. This case was decided in 1987. The appellant, a totally disabled veteran whose main source of income is federal veterans benefits, was held in contempt by the state trial court for failure to pay child support, the amount of which had been fixed by the court after considering appellant's benefits to be income under a Tennessee statute. That right there, the Tennessee statute, they can't override federal law. The state court appeals affirmed, rejecting the appellant's contention that Veterans Administration had exclusive jurisdiction to specify payments of child support from the disability benefits it provides. That is correct, of course. The court determined that Congress intended disability benefits to support the beneficiary and his dependents, and held that the trial court's order directing appellant to pay the portion of these benefits as child support or be held in contempt did not undermine a substantial federal interest, which is obviously garbage. Held a state court has jurisdiction to hold a disabled veteran in contempt for failing to pay child support, even if veterans' only means of satisfying this obligation is to utilize veterans' benefits received as compensation for a service-connected disability. The Tennessee statute, as construed by the courts to authorize an award of disability benefits as child support, is not preempted under the Supremacy Clause of Article 4, since it does not conflict with federal law, which is what you're arguing, if I am not mistaken.
So at the time, Section 211 was the paragraph of the federal law that controlled jurisdiction on veteran benefits. And Section 211 said that decisions by the administrator could not be reviewed, are final and conclusive and cannot be reviewed by any other official or by any court of the United States.
Keyword is up.
Here's
That's
that section.
right there.
Right
That's
here.
what I sent you, Steve. Now this is important for the viewers.
This is very important.
Very important for the viewers.
When the Supreme Court was looking at this case, they went out into the woods and found one Federal Register with one Senate report that said, veteran benefits provided for the veteran and their families. Now, that one expression, and their families, that's a one reference, one taken out of context reference saying, and their families. When you go back to 1883, when the first veteran benefits were introduced by Congress, it said exclusively for the veteran, not for the veteran and whoever gets to get a payment out of it. The states have never been listed as beneficiaries. The former spouse has never been listed as a beneficiary of Title 38. And even children, if the veteran has the money, the children are going to benefit from that because the veteran's going to spend that money on them. There is no point where the federal government has ever said that states have control of veteran benefits. You might find this interesting in there, but you look in this case and they said that they're going to find an imaginary and implied exception to 3101, which was the statute that said they can't garnish the benefits, they can't assign the benefits, they can't give them away by any legal or equitable process. And they said, well, that applies to regular creditors, but it doesn't apply to child support claims. And when they looked at this, they said, we're going to find an exception to this until Congress makes it clear that state jurisdiction is preempted. Preempt is a fancy word that means it's exempt from something before you look at it. Yeah. So what Congress did by the Veterans Judicial Review Act was change the exact words of Section 211, the first part, in a way that's exactly corresponds exclusively to Rose versus Rose, and no other court ruling and no other history of law. They put in there, the administrator shall decide all questions of law and fact that affect the provision of benefits to any veteran, dependent, or survivor of the veteran. So if there's a question about how those benefits are distributed between them, it belongs to the administrator. Right. In 1991,
let's pull that up real quick. General administrative provisions, is that where it is?
Section 511. So you go into Part A or Part 1.
Oh, Section 511.
Part 1, Steve.
Back. So you have to go back. Part 1.
It'll
back 1
by any court. So 211 when it became 18 months later, it got switched to 511. Okay.
Nope.
So
nope.
No.
Nope. That is a misnomer. That is misinformation that's been put out by several people. Please understand, the work we've done has been very detailed in finding where these bumps happened. Okay. The Veterans Judicial Review Act was passed in November of 1988, and it changed Section 211. Section 211 was also changed to 511, but that change did not become effective until September 1st of 1991. So 1988, 1989, 1990, Section 211 said said that the administrator shall decide all questions of law and fact. Then
look at this. Section 211 is not even there.
Yes, it's gone. Section 211 was repealed and replaced by Section 511. So in 1988, Section 211 was repealed and replaced by Section 211 updated. Do you get that?
That would have been for FY 89. So
yeah,
89, 90, and then 91.
It's not in the current law as Section 211. Section 211 was renumbered as 511 when the VA was turned into a department level executive branch with a cabinet member as the secretary. And that did not happen until 1991. So between the Veterans Judicial Review Act and 1991, Section 211 said decisions shall not cannot be reviewed by any other official or by any court. They took out the words of the United States. So when Congress repealed Section 211 and replaced Section 211 with the amended version made it clear there is no possibility that states would have jurisdiction, because states have never been supposed to have jurisdiction. Look at it. And
there it is right there.
Yeah.
So that what I sent you, Steve, that's highlighted, it shows 211 and 511. So
Right.
basically what Bob's saying is,
Congress fixed the
any court in
loopholes.
the United States is federal court. So states thought they had jurisdiction, basically. 511 said any court.
So what
Some
happened
things-
in the Rose decision is the Supreme Court actually ruled as it should have, because it said, well, the state of Tennessee is
Right.
not a court of the United States.
Right. They
Even
did
though
what they were
may not have
supposed to
agreed
do.
with it, they did what they were supposed to do, and that's why
Sure.
Congress changed the language. And
In
at least one of the justices opined that it was for the veteran and his family, but
Right.
that's not the law. Just because the judge had an opinion.
Yeah, that's not a law. That is absolutely, it does not carry the weight of law.
A lot of people
So-
cling to that argument.
Here we go. Here's the original 3 questions. Don, give us a quick, dirty rundown on these, and then I want to move on to the cases that you cited.
Okay, so the first questions we're asking the Supreme Court justices whether or not the judges are bound by the USFSPA, which is the Former Spouses Protection Act, and as Bob has cleverly named it, the Gold Diggers Act, pursuant to Article 1, Section 8 of the Constitution. So in my case, and many cases like mine, and I think Brandon's is as well, the only thing that's divisible according to the USFSPA is disposable retired pay. So if you elect combat-related special compensation and you receive that in lieu of your retirement, there's nothing that's divisible. And in my case, they said that I must pay her the difference. In the case of Mike Yorko, Eric Martin, Bill Lott, many others, they say the same thing. The judges say you have to make it up from whatever source you can, but that's a violation of 10 U.S.C. Section 1408. So we're asking if the judges are bound to that, which they are. And then we're asking if the judges are bound by the Veterans Judicial Review Act that says that, like we discussed earlier, that the veteran benefits cannot be reviewed by any court.
Okay.
Section 511. Yeah.
Right. 511, which, as Bob explained, 211, the language was changed in 1988, and then in 1991, it became 511.
Yes.
So then we're asking
That's in the notes.
if the judges are personally liable for their violations of these, which is, and they should be, because it's a violation of federal law. Their federal preemption does apply in these cases.
All right.
And you ask a lot of people, there's 2 big attorneys out there. I'm not going to mention them here, but we all know who they are, that they make a lot of money off this, and they put a lot of propaganda on their websites, and you get the barracks lawyers or the C lawyers and the former spouses that will just Google, and they'll pull up one of these websites from these attorneys, and they'll say, yep, they say it can be used, and they consider that law.
So this is very short, swift, and sweet, this whole thing, Don. It's like, and Bob, you got 3 questions, basically.
Mhm.
Can you do this, or this? Yes or no? Is that where we're at?
Yes.
Basically, are the judges bound by these laws?
Are they bound by it? Okay.
That Congress set in stone.
No, this is a really, really, really smart way to do it, because SCOTUS potentially sees dozens and dozens of cases a day. And if you send them a novel, they're just not going to read it.
You got to
Unless it has a really compelling entry.
And this one it's pretty short and sweet. It really is.
So tell us about the cases here. Let's your related cases. Wenger versus Warren. That apparently is obviously you. Lott versus Lott. Miller versus Miller, and so on.
Okay, so Lott versus Lott. Bill Lott's case was actually pending conference yesterday. His, along with Jeremy Miller out of Tennessee. Their cases are similar, so we referenced those. And then the other two I referenced earlier, Mike Yorko and Eric Martin, those two, the certs were denied for those last October. Carson represented all four of these litigants here, and Carson's cases are like they're pretty long. His petitions are pretty long, and like you said, make them short and sweet. So
yeah,
they got pretty close in Yorko and Martin, but they still didn't approve the certs.
So one last time to really clarify here, this is, you got this calendared with SCOTUS?
Oh,
and what calendared means is at one point, SCOTUS is going to see this. This is going to go in front of the Supreme Court justices. That's what calendared means. Now, from that point, they make their decision. And that's the big moment. That's what we're waiting on.
Yeah, I was trying to research this, and Bob might know a little bit better, and of course, Steve, you probably know better as well. It's like the two, Lott and Miller were set for conference yesterday. Mine is coming up on the 10th, mine and Derek's. And I'm still trying to figure out what that means. I think 4 of the 9 justices have to agree to move it forward.
Yes.
And then
that's correct.
They decide if they're going to actually hear it.
Right. It goes through basically what amounts to a selection process. You'll have to go through their clerks, which got you to the calendar. So you've crossed the first gate.
Yeah. And
now 4 of them have to decide that this is something we should look at.
Right.
So there are basically 4 gates. There's the clerk, there's that first review, there's a second review where the 4 of them approve it. It goes before, I think it's 7 of them. And they go, okay, we're going to decide on this. And then they do the actual decision. I think that's the full process, as I understand it.
Okay.
And then once they make the decision, there you go. You've got a decision made by SCOTUS.
Right.
All right.
Because they have so many cases, they have to do it that way.
Yeah. Now, when we talked about 211, 511, and the Rose case and everything, Bob, I encourage all the viewers, Pop, this is huge. I encourage all the viewers to go to Bob's page, his veteranshope.org. Look at it's everything. He has everything there waiting for you. He's done an amazing job with this.
Watch Grunt Speak live every Tuesday and Thursday at 8 p.m. Eastern. And if you want to join Pop for Supporter Sundays, go to redonkulus.com/donate and make a monthly pledge. A link is in the Meat Gazer box.